Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulo Hoyane. Another crisis is brewing in the background in the Senzo MEYIWA trial. And this time you might be asking yourself what it is. There's a lot of friction that has come up between the defense counsels in the Senzo MEYIWA trial. They no longer see eye to eye. They are going their own separate ways. And I think that is a very unfortunate development. And let me try and sketch it for you. You'll recall that when this trial started, the 5 accused persons were said to be charged with the Senzo MEYIWA trial, with the Senzo MEYIWA, the murder of Senzo MEYIWA rather, and that they had a common purpose to commit that crime. Now, what does common purpose in law entail? Common purpose in law simply means the act of one, translates to the act of the other. So that if two people conspire to commit a crime, the actual trigger puller is as guilty as the man who was going to drive the getaway car. Because the reasoning there is they had a common purpose to commit this crime. And so through the doctrine of common purpose, they are then linked with the commission of that crime and can jointly be found guilty of the crime of murder, in spite of the fact that the other one never actually did the shooting. He was just supposed to drive the getaway car. That is the easiest example that I can bring you. Now, in the Senzo MEYIWA trial, Baloyi and Gininda have provided a scenario in terms of which they are saying that it was Bongani Ntanzi and Mngube who got into the house. And it was Mngube, accused number 3, who actually shot Senzo MEYIWA. And that, I think one of the accused was outside the house. And accused number 5 was going to be the man who drives away the car, the driver of the getaway car from the scene. That is how the prosecution wants to deal with these 5 people, and they seek to link them through the doctrine of common purpose to say that even if Ntuli, the supposed or the alleged driver of the vehicle, was outside at the time that Senzo MEYIWA was killed, he is equally guilty, or is as guilty as the alleged perpetrator, Mngube, accused number 3. So that being the case, the defense then took the position that they would jointly defend the accused persons. You'll have seen how in the past, various defense counsels have come forward to cross-examine various witnesses, even though the evidence of that particular prosecution witness did not sort of directly impact on their client. And after the judge picked up this, they explained it by saying that they were conducting a joint defense. In other words, they were operating as a team to attack the prosecution case. So that is how it has always gone. ever since this trial began. Now, come the end of the state case, some of the defense counsels, at least Advocate Mnisi and Attorney Ramusipili and Advocate Ngumalo, indicated that they would be making an application for the discharge of the accused. That Section 174 application. We have seen how legal aid, or how there's been this back and forth between them and legal aid, until clear cracks now begin to emerge. Let us first of all start with Advocate Mshololo. Advocate Mshololo has made it very clear that she will not be bringing any application for the discharge of accused number 5. And I'll shortly look into the implications of that. There is, on the other hand, sitting next to him, Advocate Ngumalo. Advocate Ngumalo has said that it will take him a week or so to make the necessary preparations for that Section 174 application, and he will go ahead with the application, notwithstanding that the fact that legal aid does not want to fund it or will not fund it. So that is the position of Advocate Ngumalo. Advocate Mnisi, and to a lesser extent Attorney Ramusipili, Mnisi has indicated that because legal aid has not acceded to his request on the terms on which he had placed before them, he will not be making that Section 174 application. In other words, he's simply just looking forward to the resumption of the trial on the 25th of August, like Advocate Mshololo. Now, you see, the implications of this are not immediately obvious. But I've applied my legal mind to the possible consequences of this fallout, because it is really a fallout. Let us start with the position taken by Advocate Mshololo. You know, when Advocate Mshololo, by her own admission, says, in the face of the fact that some other defense counsels want to bring this application for discharge, when Advocate Mshololo stands up in court and says, I will not be bringing that application, she's actually breaking ranks with her colleagues. Because her colleagues are saying that, you know, the prosecution case, as it stands, at the time that the prosecution closes it, there are no prospects that any reasonable court would convict based on the evidence that has been led before court. So if Advocate Mshololo stands up and says, I will not be making that application, she's by implication saying to everyone in that courtroom that there is a case to answer for accused number 5. Hence, I find no need to bring a Section 174 application for discharge at this stage. So clearly you can see how she breaks ranks with some of her colleagues who want to go on ahead with the Section 174 application. On the other hand, there is Advocate Ngumalo sitting next to her who says, I will go ahead with this application. In spite of the fact that I'm not going to get payment for it, I'll go ahead with it. And where is Advocate Ngumalo coming from in all this? Advocate Ngumalo's standpoint is that, at least from what he intends to do by way of, you know, making that application, he is saying At this particular point in time of the trial, there is no case, there is no evidence upon which reliance can be placed so that a conviction can be returned against these people. In other words, Advocate Ngumalu is saying these people at this point in time are entitled to their discharge. And you see, if you juxtapose that position with the position taken by Advocate Mshololo, those two positions are worlds apart. Well, you can take things a bit further and take a look at Advocate Mnisi. Advocate Mnisi, well, while the initial intention was to come up with that Section 174 application, he has made it clear that in the face of all these hurdles being placed in the way by legal aid, he will not be making the application. So it is not, a decision that he lightly makes. It is just because it is simply unsustainable financially for him to embark on a 4-week preparation and not get paid for it at all. So he'll simply abandon that application based on that reasoning. So these are the way the cracks that are beginning to emerge in the defense ranks. Because you see, that initial position in terms of which they were conducting a joint defense is there in jeopardy if, at this critical stage of the trial, they don't seem to see eye to eye. And it will be very difficult going forward for him to continue to maintain that stance of jointly, defending the accused persons. And when they break ranks, the consequences could be dire because, just for argument's sake, if one defense counsel perhaps requires assistance from another, or another defense counsel picks up on something that could be of benefit to, a fellow colleague in the defense team, that person will feel no obligation at all to stand up and come to the assistance of his or her fellow defense counsel, further jeopardizing, the smooth running of this case, at least from the point of view of the defense. Because one would have expected that, having started as a team, a united team, the accused persons, the only thing the defense counsels would have concluded this trial as a team. So once cracks begin to appear, the prosecution will take advantage of that. Baloyi has caught wind of this, and he must be lining up his cars to tackle this new reality, which seems to make things a bit easy for him. So this is the perspective that I wanted to share with you this morning, that these differences that have arisen between the defense counsels could actually have very dire consequences, and implications for the overall defense strategy of the accused persons, and may well weaken it. Having said that, let me thank you for watching this video. Let me thank you for all the views and subscriptions that I'm seeing. Please like and share these videos and have a wonderful, wonderful day. Thank you.